Green Card Renewal Denials, What Every Immigrant Must Know in 2025. Today, we're exposing a growing problem that many immigrants do not see coming. Green card renewals, once routine, are suddenly being denied in record numbers. This is not a rumor. It is a real shift inside USCIS that is creating legal contradictions, unnecessary hardships, and new risks for permanent residents. If you hold a green card, this update could affect your future. The rules are changing, and you need to understand exactly what's happening. The legal foundation of green card status. Under the Immigration and Nationality Act, losing a green card is not supposed to be simple. There are only two legal ways it can happen. The first is voluntary. A resident signs Form I-407, formally abandoning permanent residency. The second is involuntary. An immigration judge orders removal after due process in court. That's it. There is no automatic cancellation simply because of travel or expiration. Lawful permanent resident status is supposed to remain intact until one of those events occurs. Historically, USCIS recognized this. For decades, renewal applications filed on Form I-90 were handled with minimal scrutiny. Approval was almost automatic unless major fraud was suspected. But starting in 2025, something shifted. USCIS began treating long absences abroad as grounds to deny renewal, even without abandonment or removal. The case that raised alarm. A recent example highlights how serious this issue has become. A green card holder left the United States for roughly 1 year due to a family emergency. When he returned, border officers questioned him, but ultimately allowed him back in. Importantly, he was not placed in removal proceedings. He resumed life in America, assuming his status was secure. Later, he filed an N-400 naturalization application, but it was denied because of his broken continuous residence. That denial was understandable under the rules. Long absences can disrupt the timeline for naturalization. But what came next shocked everyone. His green card expired. He filed a standard Form I-90 renewal. Instead of approval, USCIS issued a denial, claiming his year abroad meant abandonment. Why this denial defies logic? This decision contradicts the law. Remember, abandonment must either be voluntary with Form I-407 or ordered by an immigration judge. Neither happened here. USCIS essentially declared abandonment unilaterally, without court involvement. That is not how the system is supposed to work. It is both inconsistent and legally questionable. Even more confusing, USCIS allows him to file a new naturalization application. That filing automatically extends the validity of his expired green card by up to 24 months. In other words, the same agency that says he abandoned status is simultaneously granting him lawful documentation through a pending N-400. The contradiction is stunning. The changing nature of I-90 renewals. For decades, filing an I-90 inside the US was considered safe. Attorneys often advised clients, get back into the country, then renew. That strategy is no longer reliable. In 2025, renewal applications are being subjected to deeper background checks and stricter interpretations of travel absences. Cases that once slid through are now being flagged. USCIS is using discretion in ways never applied before, leading to denials based on interpretation rather than law. This creates enormous uncertainty. A resident with decades in the US could suddenly find themselves without valid documentation, even if their status technically still exists. The danger of long absences abroad. Green card holders must understand the consequences of extended travel. Spending more than one continuous year outside the United States triggers significant suspicion upon return. Border officers now routinely pressure returning residents to sign Form I-407 at the airport. Signing means voluntarily giving up your residency, often without realizing the impact. If you refuse, officers may still let you enter. But in many cases, they issue a notice to appear in immigration court, beginning removal proceedings. Detention is also possible, particularly if the traveler has a criminal record or appears on security watch lists. While rare, the risk cannot be ignored. The days of casual long-term absences are over. USCIS and Customs and Border Protection are far more aggressive in scrutinizing travel histories than ever before. Naturalization versus renewal, the contradiction. Here lies the strangest part of the story. USCIS denied the I-90 renewal, claiming abandonment. Yet the applicant can still file an N-400 for naturalization. Once the N-400 is filed, USCIS issues a receipt notice that extends the expired green card for up to 24 months. This happens automatically. So the system now says, you abandoned your residency, but you may still naturalize, and in the meantime we'll extend your documentation. This contradiction reveals the deeper problem. USCIS policies are inconsistent, and immigrants are left trapped between conflicting interpretations of the law. Real-life impact on immigrant families. For many families, these denials create chaos. Without a valid green card, renewing a driver's license becomes difficult. Proving work authorization can suddenly become a battle. Travel abroad becomes nearly impossible. Airlines often refuse boarding without a valid card, regardless of extensions linked to naturalization receipts. Children and spouses suffer indirectly. A parent who cannot renew a license may lose the ability to drive to work or school. Financial stability is put at risk. This is not just about paperwork. It is about daily life, dignity, and the ability to function as a lawful permanent resident in the United States. Why USCIS may be doing this? Attorneys believe USCIS is reacting to political pressure for stricter enforcement. By treating long absences as abandonment, they are signaling tougher oversight on residency compliance. However, without formal legal changes, this practice stands on shaky ground. Immigration law has not been rewritten. Only the agency's interpretation has shifted. This makes litigation likely. Courts may ultimately need to decide whether USCIS can deny renewals in cases where lawful status still technically exists. Until then, green card holders are caught in a gray area, unsure how their cases will be treated. The bigger picture in 2025. This problem fits a larger trend. USCIS has been tightening policies across multiple benefits, from work permits to adjustment of status cases. Applicants are facing longer waits, deeper background checks, and more denials. The era of automatic approvals is ending, replaced by discretionary judgment calls. The message is clear: permanent residency is under closer scrutiny. Even long-time residents cannot assume their status will be protected without challenges. For immigrants who once saw green cards as permanent security, 2025 is delivering a harsh reality check. What green card holders must do now? If you hold a green card, you must treat international travel with extreme caution. Spending long stretches outside the country is no longer safe. If you already traveled for extended periods, consult a qualified immigration attorney before filing any applications. The timing of your filings could decide your future. Keep strong records of your ties to America. Tax returns, property leases, employment history, and family connections can all help prove your residency commitment if challenged. And remember, even if USCIS denies your renewal, it does not automatically mean you lost status. Only a signed abandonment form or a judge's order can do that. Final thoughts. The contradictions in today's immigration system are placing immigrants in impossible situations. Renewals are denied while naturalization is encouraged. Documentation is withheld while residency technically remains intact. Until courts intervene, this confusion will continue. The best defense for immigrants is awareness, preparation, and legal guidance before filing anything with USCIS. We will continue monitoring these cases closely. If you are a green card holder, take these developments seriously. The future of your status may depend on the steps you take now. This is U.S. Immigration Intel, bringing you the truth behind U.S. immigration policy shifts. If you found this video helpful, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching, and we'll see you in the next video.